there's a growing awareness amongst civil liberties advocates that the quarantines are problematic from a constitutional perspective. And what I mean by that is that they're a very profound restriction on people's liberty, but there's no checks and balances like in the criminal or penal context. And so, for example, if the government sentences you, if the court sentences you for some criminal code violation, that occurs after a lengthy process whereby you're charged, and that's after an investigation. There's a review of evidence. The prosecutor decides that the case is going ahead. You have a right to counsel. You have a right to a trial. And you have a right to defend yourself and to cross-examine Crown witnesses. And none of these checks and balances are in place regarding the quarantine measures. And so the government just says, well, you're quarantining for 14 days, and that's house arrest, essentially. You're not allowed to go outside the house. You can't go out for the necessities of life. You can't even walk your dog. The Public Health Act has been around for a long time, but it's so seldomly used, and it was so restrictively used when it was used, that it didn't raise any constitutional concerns in the past because it was utilized in a very narrow fashion. It's never been utilized in the way that it has been utilized in Alberta for COVID-19, and it raises a host of issues that the judiciary needs to determine as soon as possible, really. As you know, some of these cases are currently in front of the courts in the United States, and there was a judge in Pennsylvania who has struck down the entire lockdown in that state as unconstitutional. And he said what I think many, many, many people are thinking in Canada, that just because there's an emergency doesn't mean you can take everybody's civil liberties away like this.